Clinic with New York Legal Assistance Group, where we will prepare last wills and other advanced planning documents for NYLAG's Cancer Advocacy Project clients. These documents are critical in making clients' wishes known in the event that they become incapacitated or pass away. Presenting today's training is Julie Babayeva, a supervising attorney at NYLAG, where she coordinates the Cancer Advocacy Project, which focuses on the specific disparities faced by people living with cancer. Before I turn it over to NYLAG, I wanted to briefly touch on two issues with logistics. First, the CLE verification form is attached to the calendar invite for today's training session. And second, our pro bono specialist, Edgar, will circulate the slide deck and recorded training to all volunteers by tomorrow morning. Thanks so much.
Hello, everybody. My name is Julie. Thank you for the introduction, Nagar. I'm going to just share my screen so we can get started. Everyone. So my unit within NYLAG is called LegalHealth. We are a division of NYLAG, which is a medical legal partnership. We provide free legal assistance and we develop policy to help New Yorkers who are experiencing financial hardships and people with serious and chronic illnesses. Our goal really is to bring together legal and medical professionals in the healthcare setting so we can provide assistance to clients where they are so they don't have to seek attorney assistance elsewhere. And NYLAG is one of the largest nonprofits in New York City, and we offer free legal services, financial counseling, and policy advocacy. Nagar already talked a little bit about me, so I'm going to skip this slide and just tell you a little bit more about the Pro Bono Project and LegalHealth. LegalHealth has been around since 2001, and we've partnered with hospitals and community organizations in order to help low-income people with serious health problems. It is very important that people have access to justice, irrespective of their financial circumstances. And the Cancer Advocacy Project was really started to address the disparities of people with cancer so that they can focus on health and healing, and we can alleviate some of the burdens of legal complexities for them. Why are advanced planning documents crucial? Because our clients currently are feeling like they have sort of lost control over what's happening with their lives. And this gives so just to kind of reiterate, advanced planning documents really are necessary for our clients in order for them to feel prepared and have some peace of mind about what's coming up. Again, these are people who are dealing with a cancer diagnosis and are very sick. So they have a lot of uncertainty in their circumstances in the next few months or few years of their lives, and this really gives them their power back. So this is why we do it. What are some of the advanced planning documents that we're going to be working on? It's a healthcare proxy, a living will, a power of attorney, and an appointment of agent to control the disposition of remains. So a little bit about healthcare proxy. Some of the terms that we're going to be talking about is principal, agent, and capacity. Principal is whenever a person grants their authority on behalf of another individual to make decisions on their behalf. The principal can delegate this authority and specify the scope and limit the decision-making power. The agent is the person who is chosen by the principal to make those decisions. And capacity is perhaps one of the most important on this list, is because a lot of the times the person who wants the power of attorney is the agent at this point, at a lot of points where the principal is no longer able to make decisions and does not have capacity. So our biggest sort of one thing that we always want to assure is that the person has the capacity to make those decisions. They have to understand the nature and consequences of those decisions, not just the execution and granting or revoking this document, but also who the person is that they're granting it to and the fact that they trust them to make those choices for them. A lot of times the documents that we're going to be talking about are legally complicated, and it's not that you have to sort of understand every single page of an 8-page power of attorney. It's just that the principal has to understand the authority that they're granting and the document that they're signing in sort of a pretty general way. So under New York law, a competent person has the right to consent to healthcare treatment and the right to refuse this. And they have to have informed consent where they understand and appreciate the nature and consequences of the treatment, the risk and benefits of the treatment, or any alternative treatment, and who will provide that treatment. Determination of the ability to give informed consent for healthcare decisions is made by healthcare providers specifically. And the healthcare proxy allows an agent to make healthcare decisions if the principal becomes incapacitated. The proper execution of a healthcare proxy requires that the person has sufficient capacity, again, to understand the implications of this document. But one of the things I want to mention is the legal capacity versus medically determined capacity. For legal capacity, it's something that can change daily or even hourly, depending on illness or fatigue or side effects of medication. We have had several clients who are on strong pain medications, for example, or they are going through chemo. And if you're catching them on the day after their chemotherapy treatment, they may not be with it and understand anything you're talking about and sort of be out of it. But 2 days later, they're completely fine and they have that capacity. So medically determined capacity is a little bit different. It's when a doctor basically states that this person cannot make medical or any kind of decisions based on their medical issues, but legal capacity can sort of change day to day. You kind of don't have to worry about this because the people that we're referring to this clinic, we have determined all have capacity. But it is something that you should sort of make sure, based on the fact that it could change daily and hourly when you're speaking to the client, that is there, that they clearly understand the document they're signing and who they're naming as their agent. So the authority of an agent commences once the doctor determines that the principal is incapacitated. Until such time, the principal retains their capacity to make decisions, and the authority of the agent can be limited by language in the proxy or that by the principal's wishes, as stated in the living will. And we'll discuss what a living will is in a few minutes. An agent can consult with doctors, bring in another doctor for a second opinion, or look at the principal's medical records to kind of determine what is the best treatment and course of action for their treatment. One thing to note with healthcare proxies is artificial hydration and nutrition requires a little bit of extra care in this document. So unless a healthcare agent knows the principal's wishes regarding these two things, they cannot act on these issues. It is because it's not sort of explicitly stated in the healthcare proxy. The principal's wishes can be stated in the proxy or in the living will. And it doesn't have to be a complicated statement about both hydration and nutrition. It could simply say that the agent knows the principal's wishes without specifically spelling out what those wishes are. But it does mean that the principal should have that conversation with their agents. And if they have not, you can encourage them to do that if the agent is there with them during the clinic or at another time. But it is something that's incredibly important for them to do. And these are some important points for clients that we think you should sort of state during your meeting with them. They should provide their agent with clear guidelines about their preferences regarding their healthcare treatment. They should discuss their views and values with their physician and their family. And their agent is obligated to advocate for their wishes, not decide what they think is best for them. So this is an incredibly pertinent point, because a lot of the times the person who is signing will say, my son will never take me off artificial hydration and nutrition because he just doesn't believe in that. But that's what I would want, if I was in a vegetative state, for example. And then, I think the guidance at that point would be, maybe your son is not the best person to do this, because technically it should be the person who is going to advocate for your wishes, not their own. So again, you should choose an agent who's willing and able to meet this challenge. It can be quite difficult for someone to be someone's healthcare proxy, because it's not just should this person have the surgery or not. It could come to whether or not a person should be taken off life support. So it could be a very difficult decision to make. And it really should be someone that the person trusts and can can actually follow the wishes of the principal. It is important also to try to appoint a successor agent just in case the agent that the principal appoints is unable to serve for whatever reason. And of course, make sure that your agent is willing to serve. We have had clients that would come in, sign a healthcare proxy because a healthcare proxy does not require the agent's signature. So technically, the agent doesn't have to know that they are the healthcare proxy until it sort of comes up. So we really recommend the client, the principal, to speak to their agent and let them know that they executed this document, give them a copy of this document, kind of make sure that they know what they want, so that it's not just sprung on, someone's son or someone's sister that now they have to make these very serious healthcare decisions for someone. So there is a law in New York called the Family Healthcare Decisions Act, and it does apply to patients in hospitals, nursing homes, and hospice in New York State. It does not apply to ambulatory settings or doctors' offices. And why is this law important? Is because it does empower families or close friends to make treatment decisions for patients who do not have capacity and can't decide for themselves what it is they'd like to do. But it does not apply to patients who have signed a healthcare proxy, and also where people have had discussions with their doctors about their course of treatment. The Family Healthcare Decisions Act does permit the people closest to the patient to make decisions based on the patient's known wishes, and if not known, in their best interest. The reason why this is important is because it provides a list of surrogates in order of priority who can make decisions for the patients if the patient does not have capacity. So this is sort of the list of it. It's a guardian if one was appointed for the person, then that person's spouse, if they're not legally separated, or their domestic partner, then their son or daughter who's over 18, then their parent, then their brother or sister, then a close friend. Now, why could this be a problem? If, for example, a person does not have a healthcare proxy and a decision must be made, and the person that the hospital will go to according to the Family Healthcare Decisions Act is the spouse. And let's say the spouse does not know what the wishes are or doesn't want to go through with the wishes because of personal belief or something like that. It's much better to have a healthcare proxy in order to name a person you really want to make those decisions for you. We've had people come in that say, my husband would never take me off life support. That's why I'm naming my sister as my agent, because I know she'll follow those wishes. So once again, that's one of the reasons why it's so important. And another, healthcare proxy does encourage those discussions about end of life wishes for the person and their agent. And it does make sure that the proper person is making those decisions. And another important thing is that it only applies to inpatient, hospital, or nursing home situations or hospice situations. So if the person is not inpatient, if they, pass out at a doctor's office or something else that happens like that, this law does not apply. So it is always good to have a healthcare proxy instead. Now I'm going to give you the CLE code. It's a 16077. Just going to leave it on for a second. 16077. Okay. So the next document we're going to be talking about is a living will. A living will is often confused with a last will and testament by a lot of our clients, and with reason, because they sound very similar, but the living will is a completely different document. It is a statement of a person's wishes with respect to medical care decisions. There is no statute in New York that regulates living wills, but New York State courts have recognized them as binding expressions of a patient's wishes. It is only valid for the medical situations that it addresses, and it does have to be witnessed by two adults. So when you're in your groups on Thursday, you can serve as witnesses to the living will for the client. The living will is important for several reasons. It allows individuals to express their preferences regarding their end-of-life care and medical treatment. It ensures that their wishes are known and followed, even if they become unable to communicate them. This is always a good a good sort of alternative for people who do not have a family member they feel like they can trust to be their healthcare proxy. But honestly, it is also good to do it with a healthcare proxy because it relieves the burden on family members or loved ones to make those difficult decisions because they will know exactly what it is that you would have wanted instead of sort of debating amongst themselves what they think you might have wanted. It also helps maintain an individual's quality of life by allowing them to refuse or accept certain medical treatments. And it provides legal clarity, reducing the likelihood of dispute among family members or medical professionals. So, a lot of times, this is something that we see even with a healthcare proxy, where let's say a mom names one of the children as the healthcare proxy, and the others will fight with the healthcare proxy about this decision. So, this way, the person who is named agent under healthcare proxy can show a document and say, this is what mom wanted and I'm just following her wishes. So it always helps to have that. So overall, the living will ensures that individuals maintain control over their medical care and end of life decisions, but they can't communicate and make those decisions for themselves. So a living will only applies in very narrow situations. This may be important to you on the day of the clinic because a living will sounds like a scary document. I will share the documents at the end of this presentation. I'll pull them up and we can sort of look at them together. But one of the things that a living will states is I don't want assistance, right? I don't want respiration, a mechanical respiration. I don't want artificial nutrition and hydration. I don't want this and that. And I think a lot of times people will say, oh, does this mean that if I faint on the street and I have a living will, they're not going to resuscitate me or they're not going to help me? So it is incredibly important for you to get across to the client that a living will applies in very narrow situations. Only when there's an incurable or irreversible mental or physical condition with no reasonable expectation of recovery. This statement is sort of this like the statement that is also written on the living will, but people sort of overlook it. But it is really important. If there is some chance that a recovery can happen, all of this doesn't apply. The person will be resuscitated and given all the treatment that they want and can be provided with. So it only applies in terminal situations where someone is permanently unconscious or minimally conscious and unable to make those decisions or express their wishes. So I will show you the document. There are several boxes in the document next to each statement of, nutrition, hydration, respiration, things like that. The person should initial every statement. And there are times that arise that people will say, well, I want some of these, but not all of these. What we really recommend is for the person to initial all of them, because then it sort of creates the possibility that a person didn't really want this kind of end of life care. So it is better if they can do them all. Of course, it is their choice. And if they would like, let's say, nutrition and hydration, but not mechanical respiration, they can choose that. But it sort of is better as a package. And now we're going to move on to a power of attorney. So power of attorney is almost the same as a healthcare proxy in terms of giving your ability to make decisions to an agent and naming an agent to handle one's affairs. But this one deals with banking, personal property, and other financial matters. So whereas the healthcare proxy is about medical decisions, this is about sort of financial decisions for a person. And one thing that's important about a power of attorney is that it only is valid during the principal's lifetime. So if the person dies, the authority of the agent ends, which they often don't know and will, try to take their power of attorney to the bank after the person's death and move money around, and they really can't do that until a will is executed and sort of if there's a will and the will is probated. So the authority designated in the durable power of attorney does continue after a person becomes disabled or incompetent, again, but not after they die. So they do have to have capacity while they're executing this, but if later on they become incapacitated, the power to make decisions remains with the agent. Another thing that I often get questioned on is if I sign the power of attorney now, does that mean only my agent can make these decisions and I can no longer participate in my own decision making with regard to finances? And that's not true. The principal remains the decision maker. The agent is only there to serve them as sort of a helper if they're, let's say, unable to leave the house to go to the bank or something like that. But they're not, they don't lose their own decision making power unless such a time that they become incapacitated or mentally disabled. So a power of attorney form does not cover healthcare issues, as we discussed. That's more healthcare proxy and living will. And one of the most important reasons to do a power of attorney is because it can often avoid the need to have a guardian appointed once a person becomes incapacitated. So this is particularly great for someone who, for example, has a dementia diagnosis, but let's say it's early on and the person still has capacity. They can execute a power of attorney so that if their dementia progresses and they become incapacitated, their family member or friend can continue to assist them. Otherwise, if this is something that comes up once a person is incapacitated, they can no longer do a power of attorney, there's no capacity. And then the person trying to help them has to go through a very lengthy guardianship process in the court, just a lot more complicated, takes a lot more time and a lot more effort to appoint than something like this. So definitely something to keep in mind and something that we recommend to do in order to avoid this in the future. So power of attorney has some very specific rules. You don't have to remember these, but basically I just wanted to put them out here because it's very particular. It's like there's specific font sizes that they want and everything like that. So this is the reason why we often caution clients about printing out like a sample form that they find online and doing it themselves. Why we recommend that they do it with an attorney is because when you do it with an attorney, you're guaranteed to sort of do it correctly and make sure that it's then accepted by the bank or another agency that you're trying to use it, where you're trying to use it. So some of the things that are important is that it does have to be signed and dated by the principal. It does have to be notarized. The signature has to be notarized. And it also has to be signed and dated by the agent or agents if there's more than one. There's also a way to appoint a successor agent. So let's say you have 2 agents that you appoint, and then you appoint 2 successor agents. All 4 people have to sign on separate lines with a notarized block to their signature underneath. So who can be a principal? Anyone over the age of 18 who has capacity, and an agent can be anyone over the age of 18 that the principal chooses. They can be more than one, as I said, and you can specify in the power of attorney whether they can act separately or together. One thing we recommend is to allow them to act separately, because let's say you name, 2 of your children, that means both children would have to go to the bank together in order to withdraw money from your account or do some kind of banking in order to help you. So it's better to kind of check off that box, and I will show you where that is when we look at the forms together, to allow them to act separately. You can also choose an alternate agent or agents if the first choice is not able to act or continue to act as an agent. Again, if something happens and the agent becomes incapacitated, you can choose you can choose an alternate agent in order to continue assisting you. It's important to think about efficiency and practicability when choosing agents. So for example, if your daughter lives in California and you're doing all of your banking in New York, is it really practical to appoint your daughter in California as your agent? Now with the advent of online banking and all that stuff, maybe it's not that important that a person is in person, and we certainly had that happen where people have appointed children or brothers and sisters in different states, and that is okay to do, but it is something to keep in mind for the client to make sure that it's just practical for that person to be able to assist them. To be able to like go to a Social Security office if there's an issue with their retirement, or things like that. And obviously, the most important thing when you're choosing an agent is it has to be someone you can trust, because you're basically giving them the power to access all of your finances and do with your property as they please, not as they please. They really should be doing what is best for you and in your best interest. But technically, this can be taken advantage of. So obviously, we want to make sure that this is someone they very much trust. A bit on the differences between durable and springing powers of attorney. So a power of attorney is durable unless it expressly provides that it is terminated by incapacity of the principal. And the subsequent incapacity of the principal shall not revoke or terminate the authority of an agent who acts under a durable power of attorney. So NYLAG does durable POAs only because they go into effect when they're completed. Completed means signed and notarized by the principal and then signed and notarized by the agent. This means that this power of attorney can be used regardless of the person's capacity and can continue to be used even if that person becomes incapacitated, which is what we've been talking about this whole time. The difference between that and springing power of attorney is that springing only comes into effect if and when the principal becomes incapacitated and cannot manage their own affairs. The reason why we don't recommend this is because that requires a medical assessment and a confirmation by the doctor to let them know that, to confirm that the person is incapacitated. This becomes very gray area, complicated, so this is not something that we do. This is here just in case you're asked about this. We've had clients sort of ask, can I just do a power of attorney that says it only becomes valid when I'm incapacitated, not earlier? Honestly, this is more about trust. So if a person can trust their agent to make those decisions, they should be able to trust them to do the durable power of attorney at the moment that they're executing it. There have been some changes to the law in 2021, which have made powers of attorney a little bit easier to complete. There's some of the major changes. The statutory short form of power of attorney requires wording that substantially confirms and not the exact wording that we sort of talked about before with the 12-point font and all the right words. So it is a little bit easier to kind of get the power of attorney done and accepted later on, even if it's not 100% perfect. And there used to be another form called a statutory gifts rider, which was sort of a longer, complicated form about gifting provisions. Now it's been incorporated and can now be included in the modification sections of the power of attorney. I'll show you what that looks like. Basically, a statutory gifts rider is about gifts given by the principal, gifts to be allowed to be given by the agent that are more than $5,000 for the year. So cash gifts, basically. If the principal wants the agent to be able to do that, they have to execute this statutory gifts rider provision. So now also a power of attorney can be signed by another person at the direction of the principal. This is a big one. We've definitely had clients who've had physical disabilities and couldn't hold a pen or were too sick to be able to even make a mark on a piece of paper. And we were unable to help them because you can't, some of our clients would say like, can my daughter hold my hand and like help me sign? You literally couldn't do that. That was illegal to do and against the law. So it's a nice change for those people who have physical incapacities to be able to direct another person to sign for them. And we really support that. Everyone that's coming on Thursday should be able to sign their own documents. Hopefully nothing has changed since the last time we spoke to them. But this is just a nice thing that has happened recently. So all powers of attorney require 2 witnesses. One of those people can be the notary or the attorney completing the form. It just has to be someone over 18 that's not either the principal or the agent. There were some changes to the construction sections of the statute that sort of made it easier to read. And there's an acceptance and reliance timeline for third parties who are honoring or dishonoring a power of attorney. This is also important because sometimes a bank will not accept a power of attorney for whatever reason. We've had banks return, clients return to us and say, I tried to take this to, Citi or Chase or whatever, and they said that they want us to complete their own form, but now my mom's dementia progressed and she can't sign anything. And I thought this power of attorney would be enough. And it is enough because it should be accepted. So a lot of times there's a timeline for them to get back to us to let us know that they're not accepting it so that we can rectify that if there's a problem. And there's a provision for damages and attorney's fees if there's an unreasonable refusal to accept the ballot form. Just going to do the CLE code one more time. It's 16077. So how can one use the power of attorney? This may be a question you may get if the agent, for example, is coming along with the principal on Thursday next week and is sort of there and asking questions about how they can use it. Photocopies of a completed power of attorney are legally valid, meaning they can be used as evidence of the agent's authority to act. So we usually recommend that the original power of attorney goes to the agent because they will be the one who will be asked to prove and show their ability to act on the principal's behalf. But also the agent should make several copies and definitely not give the original document. They need to submit something to a bank or another organization. Copies should be just as validly accepted. The agent will sign his or her name to indicate that they're the agent for the principal on any forms. So for example, if they're filling out a form for Social Security or a living will or a trust, they would sign, Jane Doe as power of attorney for John Smith. So they will not just sign John Smith. They have to kind of indicate who they are and why they have the authority to sign for that person. Again, this is only valid during the lifetime of the principal and cannot be used to transfer assets after death. Some ethical issues that sometimes come up is who is your client, especially if the principal and the agent show up together. Let's say the mom is doing the power of attorney, naming the daughter the agent. The daughter may have the most amount of questions and it's totally okay to answer them, but your client really is the principal. You're doing this for the principal, for the mom in this case, and it would be good to sort of ask her if it's okay to sort of answer the agent's questions and so on if they're okay with us kind of explaining things to the agent on their behalf. And we can notarize both principal and agent's signature, but both parties have to sign an acknowledgement and waiver documents. Very short, basically states that they understand that the principal is really the person we're doing this for, and that just because we're notarizing the signature, that doesn't mean we're representing the agent in any way. And I will show you a sample of what that looks like. And the last document that we'll be working on is called the Appointment of Agent to Control the Disposition of Remains. Similarly to the POA, the principal appoints an agent, then the agent knows and follows the principal's wishes as to the disposition of remains upon principal's death. This is a power that's not covered by a healthcare proxy or power of attorney, and so that's why it's an important document to complete separately. And the authority here begins upon the principal's death, obviously not before. You can add special instructions limiting the power. So if there's very specific instructions you would like I'd like my remains to be cremated, or I'd like to be buried in a specific cemetery, you can write that in. There's sections for writing that in the document appointing the agent. One thing we recommend is indicating if there's a pre-funded funeral agreement anywhere, or if someone bought a plot in a cemetery or something like that. It's very important to put that in there so that the agent is aware that this is happening and can make sure that they follow the wishes. You can also name successor agents in case an agent that you appoint is unable to serve. The principal signs this document in front of a notary and 2 witnesses again. And the document is not valid until the agent accepts this appointment by signing in front of a notary. So this can come up, for example, if the people coming on Thursday do not bring the person that they want to appoint as their agent with them. It's very possible that they're not able to make it. So what we will do at that point is we will give the original document to the principal with instructions on how the agent should sign in front of a notary. And it's sort of on the principal to then provide that document to the agent. They do have to sign the original. It can't be a copy, it can't be a scan. And only then it becomes valid. This is the same for power of attorney and the same for the agent to control disposition of remains. Are there any questions currently? I'm going to also share the documents so you can take a look at them. But while I'm getting that up, I'm happy to answer any questions.
I actually had a question. Is any guidance we're supposed to give them as to where the documents should be stored? I mean, it might be that they have copies, but like as their attorney, should we also retain copies? Is there any additional guidance we should provide on that?
Sure. So that's a really good question. Thank you. So basically, what we would ask of you sort of at the end of the clinic is to make a copy for us for NYLAG, and we will retain a copy of the documents. You know, we will have it in our system. And that way, if they lose it or if anything happens, if any questions come up, they can contact the attorney who referred them to this clinic. And that attorney can work with them to provide them with a copy or resolve any issues. Let's say if there's like a bank that's not accepting the document for some reason, they could be there to help with that. But as far as storing their own document, the sort of the original that they are going to have, what I'd like to advise them is to give the original to the person who will be making decisions. So whoever they name as the agent should probably have the original. Any successor agent should probably have a copy. The principal themselves should probably have a copy. And I warn one thing I sort of warn against is storing it in something like a lockbox or something like that in like a bank, because you want to be sure that this is easily accessible. So if a person becomes incapacitated and can't go to the bank and open their lockbox, how is anyone going to find this document and be able to use it? So it really should probably stay with the agent, and the agent should keep it safe however they can. But that's a really great question. Can everyone see my screen? Just make sure. I just want to make sure we don't have the same problem as before and you can see my document. All right, I'm showing you here power of attorney and what that looks like. So the power of attorney should be filled out typed here. So what we recommend for each team of two, one of you should have a laptop. It doesn't have to be both of you. And that person can enter the client's information into these documents. There are points in these documents where things have to be handwritten, and I will point that out to you. So basically, this is just name and address of the principal, name and address of an agent, and a second agent if there is one. This is the area where the agent can notify whether the principal can check off to give the authority for agents to act separately. So this little box needs to be initialed, not a checkbox. They have to put their initials here by hand, not typed by hand. Successor agents would go here. Usually there are no specific instructions that we enter here. And then this is sort of the most important page. This is the grant of authority. So these are the types of authorities that a principal can give to the agent. Usually, in order to be able to fully act with regard to all financial matters, we recommend that the principal says yes to all of them. Because if something comes up and it's not checked off, the agent won't be able to act on that behalf. So in order to do this, we don't have to initial every box. what we do is complete, we write in A, comma, B, comma, C, and so on. We can't write A through O because they don't like to accept this, and we've had issues with this before. So please write out every letter with a comma in between. And then the principal will initial just this last box. They don't have to go through all of the boxes, but it does have to be initialed by pen, not typed in. Now, this is sort of the gift writer that I was talking about that used to be its own separate like 5-page document. Now it's easier to do. If the person wants to give the authority for the agent to make gifts in excess of an annual total of $5,000, they have to initial here. A lot of our clients are very low income and they won't initial just because they don't have that kind of money. And these are optional modifications. So the principal doesn't have to initial any of these if they don't apply to them. However, a lot of our clients are dealing with things like SNAP or Medicaid or other sort of government benefits. They live in NYCHA housing or Section 8, things like that. So a lot of times it is appropriate for them to initial these. So just discuss them with your client and see what sort of applies to them. And if it does, they can initial these. There's a bunch of them. As you can see, a lot. So we don't usually recommend monitors because monitors need to be paid. And so this is something that our clients don't usually initial, or it doesn't really apply to them. And then another sort of most important point of here is here on page 10, the principal has to sign and a notary has to notarize. So I'm a notary. Some of our paralegals that I'm bringing with me on the day of the clinic are also notaries. If you're a notary, please bring your notary stamp with you. You can notarize this document, or you can use one of us as your notary as well. And then this has to be witnessed. Both of you on the team could act as witnesses, and the address is that of your firm. You don't have to put your personal address. This is information to the agent about acceptance of their authority. And again, the agent has to sign here. So this could be a little confusing because it says I/we. So if you have one agent, obviously just one name goes here. If there are two agents, both of their names will just be put here, like, you know, Jane Doe and John Doe. And then each of them will sign on each line here, and each signature has to be notarized separately. That's something that has happened before, where a notary, you know, we would give the document to the principal and they take it home, and their like son and daughter will go to a notary to sign, and the notary just does one block. It was rejected by the bank and we had to redo it. So it does have to be notarized in 2 blocks. Any successor agent, same idea, 2 blocks, 2 signatures. So that's the power of attorney. This is the living will. And again, you know, we discussed the wishes, you know, this person is of sound mind. These instructions reflect their settled commitment to decline medical treatment under the circumstances indicated below. And this is bold for a reason: incurable, irreversible, mental or physical condition with no reasonable expectation of recovery. So this is something to drive home for the client, that it's not, you know, just generally like I went to the hospital for a broken leg and they're not gonna like resuscitate me if I go into cardiac arrest. Like, that's not what this is about. So it's very important for them to know that. Here, again, these are the boxes I was talking about that the client has to initial by hand. Cardio, pulmonary resuscitation, mechanical respiration, artificial nutrition, hydration. I do not want antibiotics. Is kind of a weird one. I think people have questions about, and they say, why would this be something that I worry about? So a lot of times antibiotics can sort of artificially prolong someone's life, just like artificial nutrition and hydration. And so when you're sort of saying no to that kind of resuscitation, you want to say no to this as well. So these are things that people should initial. If there are any other directions, a client can feel free to type this in here. You can handwrite it, you can type it in. whatever's easier for you. Then the person is going to sign and you're going to witness. There is no notarization here. This is optional. This is organ and tissue donation. If the person would like to make an anatomical gift, they can initial a box here. If there's any limitations, like I don't want to donate my eyes, they can put that there if they'd like. And then they would sign date and put their address. This is not a notarized form. I want to
I have
show
a
you.
quick
Yeah, go ahead.
question. Will there be, is there a specific address they need to put in? Is there particular information they need to put in to make this valid? Like if they have questions about what address to put in or what information?
It's whatever, it's their address, right? It's wherever they live or wherever they is their place of residence. They would put that address. No other specific information, just like their name and then their address and date and their signature. Sure. So we're also going to include sorry, I should have talked about this when we were discussing powers of attorney. This is the acknowledgement and waiver that applies only to the power of attorney. This is the document where if the agent is going to be there with the principal and we're going to be notarizing both their signatures, this is the document we have to execute. Basically stating that, you know, they understand that the attorney is representing the principal and so on. So this is a very short form. We're just putting the name, signature, and date of both agent and principal. This is an affidavit of translation. I don't think we have any Spanish speaking clients as of now. We might have a few additions before next week, but as of right now, this doesn't really apply. But if you do have a Spanish speaking client on the day of, and if you're using an interpreter, that interpreter does have to submit an affidavit of translation for a power of attorney that they sort of read this document to the client and they know, you know, both the languages that they're using. And finally, this is the appointment of agent to control disposition of remains form. Again, principal's name and address, name of agent, and any special directions. So this is where we can put in like, I would like to be cremated, or, you know, whatever other specific instructions the person wants to leave for their agent. This is where they would indicate if there's any pre-funded agreement, funeral agreement. And this is where we would put in the agent's name, address, phone number, name any successors if you'd like, if they'd like. And then this person needs to sign and it needs to be witnessed and accepted by the agent. So again, if the agent is not there, we're completing this document, witnessing the signature of the principal, notarizing it in the case of a power of attorney, and giving the originals to the client so that with instructions of how the agent is to sign this in front of a notary or not, depending on the form. Okay, I think those are all the forms that I have. And let me see if there's any other sort of housekeeping logistical things. Let's see. So again, the clinic is on Thursday. It's between 1 and 4. We're going to begin all together and just kind of talk about logistics of, you know, where everyone's going to sit and tables and rooms and things like that. Each person will be assigned a room or a desk with your clients, and a NYLAG staff member will be available for questions. And so before you sort of done with the client, what we would ask of you is that once you fill out the forms, before you print them out, let us have a look at them. And then once you print them out and you have the client initial and sign and notarize everything, let us have another look at it before you let the client go in case anything needs to be corrected. And then please make a copy for us for NYLAG, and then the original would go to the client. If you have any forms that you've saved on your computer and you would like to just share them with me in case client loses a form or anything else. That way I don't have to start from scratch. If they ever need to come back to us, please email them to me and I'll provide my email address. Again, my team and I will be there the day of to answer any questions and provide any kind of support. And I just want to say thank you very much to all of you for volunteering your time. It is incredibly helpful to our clients and to people who are really sort of struggling with so many health issues. And this is just going to be such a relief for them to have this off their plate. So really, thank you. I'll take any other questions if there are any.
Just one other quick question, and thank you so much. This was really helpful. How many different principals would we expect to, and clients would we expect to be helping on the session for the clinic?
Yeah, I think we're aiming for 8. And each person is going to each client will be helped by 2 people, 2 attorneys. So you will be in groups of 2 with 1 client each for the duration of the clinic.
Got it. Thank you.
Sure. Any other questions? Okay, thank you all very much.